Hi, my name is Amanda Rocha. I am an estate planning attorney in California, and today I am answering the question, what is probate? You probably have heard me say, probate is bad. You want to avoid probate. Why should we avoid probate? Well, here are a few good reasons. First of all, what is probate? Probate is the court process in which a judge will determine where your estate items and property go after you've passed. There are a few avenues you can take to get to probate. First and most interestingly is if you have a will and only a will, you do not avoid probate. You still will have your will submitted to the court to be proved. The judge will look at the will, make sure that everything is in order. Hopefully all of your items are listed on the will, but not everything can be. And they'll make sure that the will was properly executed. Another way you can get into probate is if you pass away without an estate plan or with an inadequate estate plan. So if you die without an estate plan at all, it's called dying intestate. And that will automatically put you into probate unless you have less than $166,250 of an estate. And that is numbers for 2020 in California. Everywhere else has a different standard, and every year that's subject to change. So as of 2020, if you have property worth more than $166,250, not necessarily just property, but I'll get into that in a second, you will need an estate plan. And what I meant by not just property, your estate value is worth more than what actually will go through probate. So your estate is added up based on real estate you own, any personal property you own, vehicles, etc. And then your life insurance amount and any retirement benefits, your bank accounts, all of that is added up to determine the value of your estate. But what actually goes through probate is not life insurance and not retirement benefits. Those will be issued to the beneficiaries you listed when you filled those documents out in the beginning. Also, property doesn't necessarily go through probate if it is jointly held. Let's say you have a spouse and you both own property, and the surviving spouse receives the property that you co-owned. You wouldn't have to file probate for that specific property. However, if you have separate property, that can be a different story. So it only matters for jointly held property. Or let's say you own property in a different way, tenants in common. And if you don't know what that means, you probably don't have it, but you should probably check your deeds anyway. You have multiple owners on one property. It will say, or it will go by default of law, in which you should have figured out when you owned your property with multiple people what will happen once you pass. And so this is a red flag for you. If you own property with more than one person and you don't know how it's held, go to your deed and look at it. And if you do not understand, talk to an attorney, because there are many different things that can happen if you become incapacitated or pass away. So that being said, probate will generally look at your property. Now, how long does probate last? That depends. And I know that's the most lawyer answer you're going to hear, but generally probate is 12 or 18 months without an extension. Now that is if you have an executor who has everything in order and there are no issues, nobody's contesting the probate, no creditors are having issues, and that sounds like, we'd all think that our probate would go that way. It doesn't always. So minimum 12 to 18 months. Who is involved in probate? Well, first you have a judge, and the judge will assign an executor. Also could be called a conservator or a personal representative. All of those terms are interchangeable and they're the same person. Most of the time this person is a family member if one is available, and those people probably don't have any experience with probate. And if they do, they're not experts. They don't know exactly what to do and when, what forms to fill out, and how to do it properly. And the judge does not hold their hand. In fact, the judge usually has no oversight whatsoever as to what the conservator does. So it is recommended that you would hire a probate attorney as well, who can guide your family through what's going on. Family or friends. We're assuming here that a family member will do this. But actually, a family member doesn't have to be the only person that files a probate case, that petitions the court to open, is what it's called, petitions the court to open a probate case. Creditors can do it. So if you pass away and you have creditors, they find out that you've passed, they can open a probate case on your behalf, and everyone has to be involved. How much does probate cost? This is probably the most motivation, the cost for people to get an estate plan in order. Costs for probate are statutory, meaning set by law. So the executor and the probate attorney both are paid a percentage based on the total amount of your estate. If you look at the link below, you can go to my blog post about what is probate, and I have listed several examples that I'm not going to talk about here. If your estate total was X, then the executor and the attorney will make Y and Z. And just know that it adds up very quickly. Another reason you'd like to avoid probate, besides the time involved and the hassle and the cost, is that it is public. So anything you have, anything that you put into probate is available for everyone to see. And that can be a problem if you're a private person. It could be also a problem if you have potential, I don't like to use the word illegitimate, but unclaimed children who can come into the picture and decide that they deserve a piece of the pie, so to speak. So also creditors will see this. Creditors won't see it because it's public, but because if you file for probate, you have to, by law, notify all potential creditors. So then here they come knocking at the door and making the process go on longer, ending up costing probably more money. Another issue is a contested will, or contesting the estate through an intestate estate, which means someone says, I don't believe that what was in the will was correct, so I want to argue my case to the judge and tell him why I think I need more or less, or this person doesn't deserve something. So these are all reasons to avoid probate, and that's all well and good, but how do you avoid probate? Just having a will, as I said, doesn't avoid probate. Having a trust alone does not avoid probate. You have to have a complete estate plan, meaning anything that you've owned should be put either in trust or somehow transferred to out of your name, so that when you pass away, you personally do not own more than the threshold amount of money. Then you don't qualify for probate. There are many ways in which to do this. It's not simply adding everything to a trust. It's not transferring everything during your lifetime, because there are major tax implications for that. I will talk about that in a future episode, but if you want to ask specifically, please let me know. And property values will be affected if you transfer during your lifetime as opposed to afterward. So having a complete and proper estate plan is very important in avoiding probate. If you have any questions about probate or questions about what I've talked about today, please let me know. You can contact me through the contact page on my website, www.amandarochala.com. It is a top menu item, contact, or you can respond in a comment below on this video. If you'd like me to create another video on a topic of your choice, please let me know. I would be happy to do so. I hope you have a nice day.